Welcome to Perverted Justice. This is not just a story. It's a call to action for integrity and radical honesty, in spite of personal cost. Now here's your host, Shielagh Clark.
Welcome back. This is episode 21. So today we're going to talk about damages and trial, how it all would have gone if the church hadn't lied to avoid facing one, and then we'll talk about what did happen because they did lie. Any loss, whether it be financial, emotional, physical, or otherwise, resulting from the actions of another, are called damages in civil law. The plaintiff, or the harmed party, must prove not only that the wrong occurred, but that it actually caused a loss of some kind. That loss is then given a value by a jury after trial, which is the judgment against the offending party. The idea here is to restore balance between the parties, to appropriately compensate for the harm done, even though money obviously doesn't repair most loss. As an interesting side note, in defamation cases, there are 3 categories which New York State considers so egregious that a plaintiff's damages are assumed, meaning that if the plaintiff successfully proves the defamation happened, they do not need to go on to prove any evidence of harm, because the court already assumes that it was harmful. One of those categories is lies about the sexual promiscuity of a woman, which ironically is exactly the lie many people at Hyde Park Baptist Church have told about me, but the court doesn't assume harm when a child is sexually abused, and that's just wild to me. So at trial, the court would have expected me to present evidence that Jonathan Weaver abused me, that the church knew or should have known about that abuse, and that they were negligent in their handling of him as an employee and of reports of that abuse. Then after all of that, I would have had to prove that this was damaging to me. So in New York State, these trials are bifurcated. Basically, that means 2 trials in one. So let's break that down. The first part of the trial is to apportion fault. We would call witnesses to present evidence of abuse. The church would call witnesses to attempt to poke holes in my evidence. And the jury would determine if I was likely abused, and if so, to what degree Weaver and the church were each at fault. So, if the total fault is 100%, the jury would say, okay, Weaver is 50% responsible and the church is 50% responsible, or Weaver is 30% responsible and the church is 70% responsible, okay? But if the jury decided that the abuse likely did happen and the church was 0% at fault for it, the trial would have ended right there. We never would have gotten to the second half, okay? If the jury had decided that the abuse likely did happen and the church did bear some responsibility for it, they would determine what percentage of the liability belonged to each party, the church and Weaver, and then the trial would continue to the second half, where I and others would then testify to damages, how harmful the abuse and the church's response were to me, and what losses I've suffered over time because of it. I'm not going to get into detailing any of those in this episode, though we will likely touch on many of them in season 2. When asked directly about robbing me of my chance to speak the truth in court, Alex Valentine admitted that he does believe I would have won the case at trial. But he claims that the problem is that this is a liability case. I don't understand what that means. Besides this meaning that he's acknowledging that it would have been plain to a jury at trial that the church was indeed at fault, which would have resulted in a judgment against the church, I don't understand why he's presenting a liability case as being a problem. In my view, getting a jury to correctly parse blame is part of truth-telling. But then again, I guess when you're allergic to the truth, an avenue for telling the truth plainly looks like a problem. As we were approaching trial, we hired an expert witness who did a 9-hour assessment of my losses and then performed several more hours of interviews with third parties to determine the extent of my damages. She wrote a report, and she was slated to testify at trial. In those same weeks leading up to trial, the church began filing motions to preclude evidence from trial. They asked the court to bar the testimony from the expert witness and her report, to prevent us from presenting evidence that Jonathan Weaver was allegedly arrested for soliciting prostitution in the early 90s, and to prevent Weaver's first known victim from testifying at trial. They argued that the prostitution issue and the first known victim were irrelevant to my case, and that even if they were relevant, they would prejudice the church more than offer probative value. We didn't care about the prostitution bit, so we were glad to let it go, but we did fight back against the expert witness and the first victim's testimony being barred from trial. Ultimately, the court sided with us and allowed all the needed evidence to come to trial, so we were set to go. Everything was looking pretty good. We called several witnesses that I think I'm just not going to list all of them right now, but the church only called 2. They called Jonathan Weaver and the officer who came to the church in 2005. So because they would have had a hard time compelling Weaver across state lines, Weaver's trial testimony was recorded in Pennsylvania before trial. I was glad that this happened because up until that point, he was allowed to just stay quiet. So Weaver hired a third attorney to represent him for this because it was in Pennsylvania. So he had a retired attorney in New York, he had an attorney in South Carolina for the criminal case, and now he's hiring his third attorney to represent him for his trial testimony. And he exercised his Fifth Amendment rights several times, but he did answer some questions and even admitted to having me in his office with the door closed prior to age 18, among other things. His wife, Lisa, was present for his trial testimony, and she can be seen in the background of the video taking notes throughout. Whether these notes were to grill him afterward or to keep track of his testimony over time, I have no idea. But how she could possibly still believe his nonsense at this point is beyond me. We obviously never made it to trial, which I'll get into in a minute, but I think the church's limited choice of witnesses tells us quite a lot about what direction they were headed for trial. I mentioned earlier, in an earlier episode, that I suspect there was an agreement reached between the church and Weaver, likely between their attorneys, that they would drop Weaver from the lawsuit with the understanding that if this went to trial, he would testify on their behalf. And in his pre-recorded trial testimony, Weaver played the loyal soldier. He repeatedly and very confidently stated that the church didn't know about his sexual involvement with me, that no one suspected anything, and no one ever approached him about his behavior being wrong or questionable. This obviously contradicts Pete Nargi's own testimony, and when presented with Pete's signed statement to the insurance company from 2005, Weaver had to change his tune.
Does this in any way refresh your recollection about having any conversations with Peter Nargi?
Perhaps.
All of a sudden, he did remember that maybe Pete did approach him.
He may have brought it up at a time, but not to the point to where it raised any flags on my part.
So, listen to Weaver slip up here.
Are you appearing here today pursuant to subpoena issued by my office on behalf of the Hyde Park Baptist Church?
Meaning you asked me to come and compelled me to come because of the subpoena?
Yes.
Yes.
Listen to him deny the church knowing here.
Now, at any point, did you take steps to conceal the nature of a relationship that you had with Shielagh from members of the church?
Yes.
At any point in time, to your knowledge, did any member of the board become aware of anything of the nature of your relationship with Ms. Clark?
No.
In regards to that, what, if anything, did you tell Shielagh about telling other people about the nature of your relationship?
Instruct the witness not to answer and invoke your Fifth Amendment privilege.
Were you ever questioned by any member of the church with regard to any of your interactions with regard to Shielagh?
Say it again.
Were you ever questioned by any member of the board of the church with regard to your relationship with Shielagh?
No.
The other witness they called was the officer who came to the church in 2005 to receive my first statement. I suspect he was called so that the church could ask him to testify about why the charges were dropped in 2005. This is something we'll get into in great detail in Season 2, but I called off the investigation twice out of fear. The second time, Weaver actually called me shortly before the police had intended to orchestrate a recorded call in order to record a confession from him. I have no idea how he knew or how he got my new number, but I told the police that I was done after that. I remember I called Officer Banks to tell her that I didn't want to move forward, and she asked me directly if Weaver had contacted me, and I lied to her. I said that he hadn't called me because I was afraid. And she knew it. I'm sure she dealt with this sort of fear a lot, but she couldn't force me to continue. So she had me come in to write a letter and sign it, saying that I didn't wish to pursue charges in New York or any other state. I'll post a link to this document in the show notes. In these same weeks leading up to the trial, Dan Ecker, who was the moderator of the board when my abuse was exposed, told at least one person who supports me that the board and Pete Nargi have nothing to apologize for because they, and I quote, tried to have Weaver arrested, and do you know who stopped us? Shielagh Clark. And we have the paper to prove it. End quote. That last piece is particularly telling because the documents in my case were under a confidentiality agreement, meaning it was strictly prohibited for any documents from the case to be shared outside the lawsuit. Yet Dan Ecker is claiming to have or to have seen a paper showing that it is solely my fault that Weaver wasn't prosecuted in 2005. Pete Nargi was given a copy of the police report documents during his deposition so he could answer questions about them, and Dan Ecker was Pete's support person throughout the civil process. It doesn't take much of a leap to figure out how Dan got eyes on confidential documents during litigation. Documents Pete was clearly told were confidential. Here.
We do have a protective order in this case, and a lot of these documents that were shown are confidential. So we just ask, this has to stay, it's under protective order, so it needs to stay confidential within the lawsuit. Counsel, we just ask that this doesn't leave the lawsuit. Your client can't discuss this outside of the lawsuit. Put something on the record.
That, and I believe my client understands that and would have no desire to share these documents anyway.
Okay. Recording stopped.
Regardless, the document isn't the smoking gun Dan pretends it is. Calling the police and then blaming the victim and calling her abuse an affair is hardly evidence that you tried to have the abuser arrested. And Dan and Pete both know from personal experience what supporting a victim through the criminal process actually looks like. And they both know that they did not do that for me. Also, during these weeks leading up to trial, the rumor mill was churning pretty hard, and the main thing flying around was this insistence that I was only demanding a trial because I just wanted more money. That was maddening, but it was not completely unexpected. So, as we were all preparing for trial and my family was finalizing travel plans, the church filed a notice with the court to announce their intention to file for bankruptcy just 2 business days before trial. My attorneys called me to tell me and to explain that this meant that the trial was not happening. I'm not even going to try to explain to you what it felt like to receive this blow, because it would be impossible and pointless to try. But once I collected myself, I called my siblings individually, and most of them dropped what they were doing to come to my house to just be with me. It was helpful to listen to my siblings express their contempt for a church that would lie to avoid accountability, and we all just spitballed ideas for how to pivot and recover from this unimaginable loss of my trial. I've been working towards this for 4 years, and then at the last second, got the rug just completely ripped out from under me by dishonest and unethical people. The press conference, the protest, and the podcast were all born that night. My siblings all assigned themselves tasks, and we pulled off a pretty amazing thing in a very short amount of time. But back to the cancellation of the trial. Remember how many times I've mentioned throughout this series that the church had power to decide how things went, and how they repeatedly claimed to be powerless and blamed the attorney for everything that was filed and done on their behalf. They acted completely powerless. Remember how Murray actually claimed that I was suing the insurance company and not the church? So he was completely powerless to make any decisions about how things went forward. This is what they were telling people to excuse the nonsense that was happening. Well, it turns out I was right all along. The church hadn't stepped in to maintain any kind of integrity during the litigation because they were benefiting from their attorney's strategy. But as soon as they were dissatisfied with the insurance-appointed attorney's inability to settle the case, and they realized that they were rapidly marching toward a trial in open court, guess what they did? They hired a second attorney. Just like that. Like magic, they suddenly found the power to decide. They suddenly have the ability to hire secondary counsel in order to exercise control over how things went. Just materialized out of thin air, as soon as what was happening was not in their benefit. Not to their benefit. Unfortunately, when they finally decided to act, it wasn't for righteousness' sake. It was to play dirty, to lie, and to rob me of the opportunity to be heard by a jury. And when pressed about why they would lie to cancel the trial, Alex Valentine still said that was the advice of the attorney at the time. So they step in to take control and still pass off the responsibility to the attorney that they hired for that specific purpose. The real kicker, though, pay attention, this attorney that they hired to help them lie is the father of Dale Blue's son-in-law. This is the same Dale Blue who claimed to be afraid of unscrupulous attorneys. Remember he said this?
You're afraid of what?
Unscrupulous attorneys. That's all I was afraid of.
It seems he doesn't actually care what kind of attorney the church hires or what methods they are willing to employ. The concern for a lack of scruples only applied to my attorneys, and Dale's debilitating fear of unscrupulous attorneys was born out of his belief that I would resort to hiring an unscrupulous attorney. You know how they say accusations are often confessions and people see the world the way that they are? Both seem to apply here in this situation. As previously stated, I cannot and will not discuss my settlement agreement, but the initial notice of bankruptcy came with a settlement offer of an additional $25,000 from the church. First, if you're bankrupt, where are you getting $25,000 from? Second, what an insult. And third, for the 97 millionth time, I didn't want their money. Throwing more of it at me wasn't going to motivate me to settle, nor would it justify robbing me of my trial in the 11th hour. So things moved pretty quickly after that. The attorneys sorted out details and had several meetings that I wasn't part of. I know that Dan Bradford, recently appointed chairman of the board, who grew up with me, by the way, were the same age. His mother and my mother were friends. He attended at least one of these meetings during which the church's new attorney admitted that the only reason that they were threatening to file bankruptcy was to kick my trial off the calendar. He actually admitted this. My attorney couldn't believe her ears. She was so shocked by this admission that she literally stopped her car in the middle of the road and asked for clarification. So there are a couple things I just want to make clear about the bankruptcy because this seems to be confusing. First, the church was not bankrupt. Second, they did not actually file bankruptcy. They only threatened to do it if I refused to settle. Third, even if they had filed and kicked the trial off the calendar, the trial would still need to happen later to finalize their bankruptcy. Fourth, they didn't need to file before trial. They want you to believe that they had to step in and do this to protect themselves because I wanted to destroy the church and I wanted to take all their money, which I literally couldn't do, right? This is what they told the congregation ahead of my trial, that I was demanding an exorbitant amount of money, so they had to file for bankruptcy to protect themselves and their assets. But they could have just as easily filed after trial and received the exact same protections. Fifth, this was only ever a tactic, a way to force settlement and keep their bad behavior out of the public courtroom. And sixth, if I thought I could have endured it, I could have paid $50,000 to hire another attorney to have them sanctioned for improper use of bankruptcy law, and then get my trial back on the calendar. But I knew I needed to be done. So I decided to tell the truth another way, on my own terms, much more publicly than in the courtroom, this podcast. So I signed the settlement agreement, which I can't and won't discuss, and then made a post on Facebook announcing that I would be holding a press conference on the courthouse steps on April 15, 2024, the day trial should have begun. The church saw it and complained to their attorney, who then tried to withhold the church's signing of the agreement until I canceled the press conference. They forced me to settle and then try to withhold the signing of that document until they can also try to force me to be quiet. They want to stop my trial, and then they want to try to silence me. Obviously, that didn't go their way. I still had my press conference. They had to sign the document. I'm going to go ahead and read what I said from the courthouse steps. We should be filing into the courtroom this morning to select the jury for a long-awaited trial, where the truth of my life would be laid out plainly and publicly. But we're standing here on the steps outside instead, because just as 20 years of suffering and 4 grueling years of litigation were about to give birth to truth, the Hyde Park Baptist Church halted the legal process. On April 5, the church filed a notice with the court stating they intended to file for bankruptcy on April 11, a mere 2 business days before trial. This would have put an automatic stay on my case, forced my trial off the calendar, and made me a claimant in a lengthy bankruptcy process where I would need to spend thousands of dollars and who knows how much time fighting to get my trial back on the calendar. I have spent the days since weeping at the injustice of being robbed of the opportunity to have the truth told. When you think of victims, you're supposed to think of liars and quitters and a lack of personal responsibility. Survivors suffer greatly from this societal conditioning. But when you think of church, you think of righteousness. The church benefits hugely from this association. Ironically, righteousness and justice are interchangeable terms. Over and over, God commands the church to do justice, to act righteously, to plead the cause of the innocent and the oppressed. Instead, the church often pleads the cause of the institution. Jesus leaves the 99 for the one, while churches often abandon the one in favor of the group. It took me a long time to understand, but the Hyde Park Baptist Church has attempted to define my existence for their benefit for as long as I can remember. During my abuse, many called me a teacher's pet in order to excuse looking away from the obvious signs of abuse. After disclosure, they framed my involvement as consensual and required me to publicly apologize for being abused in order to hide their failure to protect me. When I was raped in the aftermath and begging for help at the brink of suicide, they called me an unrepentant liar, believing my abuser over me, in order to excuse their failure to appropriately assign blame. And now, many within their ranks call me money-hungry, greedy, immoral, and a liar, in order to excuse their failure to defend me. There are grown men walking around this community today blaming me and my inability to face the justice system alone in 2005 for their failure to support me. There are former and present pastors and deacons claiming I'm telling lies to legitimize my case in order to excuse their failure to tell the truth. And where they can find no fault with my behavior, they blame the behavior of others on me. For so many years, I believed the lies they told about me, constantly trying to change myself to fit into the boxes that would make me worthy of love and protection. See, the difference between me and most of the past and present leadership of the Hyde Park Baptist Church is that I have doggedly held on to the idea that they are good, just misinformed, while they labeled me as immoral, divisive, and troubled. I have begged and hoped and cried for healing and redemption and unity, while they have cried persecution, joked about my lawsuit, and publicly prayed 30 days of imprecatory psalms over my life. I have allowed for human error, fear, and misunderstanding as reasons for their failures, holding buckets of grace just waiting to be poured over people who have harmed me, while they utter damnation and accusation. From day one, this lawsuit has been about the truth. Not about whether Jonathan Weaver did what he definitely did. That's what the criminal case was for. But the truth about how the leadership of Hyde Park Baptist Church failed to protect me from him and then destroyed me after disclosure, nearly driving me to take my own life. I wanted them to understand where they went wrong and why, so that it never happens to someone else. I wanted an independent investigation so the truth of what happened could be published publicly. I wanted institutional ownership of harm done and an apology. I would have settled my lawsuit for those things right up until 2 summers ago. In the summer of 2022, I broke rules to sit down and speak with 2 leaders of Hyde Park Baptist Church. Despite my prior attempts dating back to before the lawsuit was even filed, I still felt morally obligated to try one last time, to wave a white flag and help them to understand what was never my responsibility to explain. I wept in front of them, explaining how deeply wounding their responses have been. I told them what I wanted was the truth exposed, and what I did not want was their stupid money. They promised me they wanted to find a way to right the ship, but nothing changed. This only harmed me further, but I don't regret my efforts, to be clear. The rumor mill has been running pretty steadily in recent weeks, with many people declaring that I wasn't settling because I just wanted more money, and I wanted to destroy the church, ignoring the obvious fact that in order to get to trial, I have to prevent settlement. I guess it's hard for the church to imagine this not being about money when money has been their only focus. It's so much easier to demonize a victim than to address its own failures. Faced with the prospect of years more silence, wondering if my witnesses will still be available by the time I make it back to the courtroom, I was left with no choice but to pivot. They may have strong-armed me into a settlement by weaponizing bankruptcy law loopholes, but they cannot force me into silence. Though I will honor my settlement agreement and keep the terms and conditions of that agreement confidential, as of this Friday, my voice is free, and I intend to drag every bit of the truth out into the light. I never imagined coming to understand so clearly that the church is often the darkest place on earth. It remains difficult for me to understand how the people who taught me Scripture as a child could struggle at such a fundamental level to live any of it when it's hard. Woe to you, teachers of the law and Pharisees, you hypocrites! You give 1/10 of your spices, but you neglect the more important matters of the law, justice, mercy, and faithfulness. You should have practiced the latter without neglecting the former. Matthew 23:23. I'd like to thank everyone who's come alongside me these last few years, and especially the last several days. It has been difficult to process abruptly losing everything that I've worked so hard for over the last 4 years, but my people have propped me up and urged me forward. I am indebted always to the survivors and attorneys who worked so hard to pass the Child Victims Act, which gave me my voice back after so many years of silence. And I'm grateful to my attorneys who have fought to keep my voice free through this process.
If your community is dedicated to fostering a safe and supportive environment, connect with GRACE, Godly Response to Abuse in the Christian Environment, at netgrace.org. GRACE's mission is to empower Christian communities to recognize, prevent, and respond to abuse effectively. They provide vital resources and training to help churches understand the complexities of abuse and adopt effective prevention policy and trauma-informed responses.